Okay, welcome everyone to Thursday, March 12th, 2026, meeting of the House Judiciary Committee. We are going to get started here. Okay. I'd like to call HB 1222. That is you, Prince George's County Delegation.
Got it. All right, moving. Oh, good, you're here. Yes.
All right. You may proceed.
All right, good afternoon, Madam Chair, members of the House Judiciary Committee. I am Delegate Nicole Williams. I serve as chair of the Prince George's County House Delegation. I do have someone with the County Executive's Office here if there are any additional questions about this piece of legislation, but it does have the support of the County Executive as well as the State's Attorney. Sorry, I'm trying to catch my breath here, for Prince George's County. And so we are asking for your support of House Bill 1222. This is a bill that would increase the future salary for our Prince George's County State's Attorney that will go into effect after the election. So this will not increase their salary at this moment. The county executive, as I stated, is strongly in support of this legislation because it allows us to provide compensation on par with other counties in the region and really recognizes the critical work that's being done by the chief prosecutor for our county. The Prince George's County State's Attorney works to protect the rights of the people of Prince George's County as our primary law enforcement agency and handles everything from minor traffic offenses to homicides with a dedicated team of over 200 employees. And in fact, our county executive served as the state's attorney before assuming her current role and understands how challenging and consuming the position can be. And so just as a comparison with regards to the other salaries within the region, Montgomery County currently is at $251,000, Baltimore City is at $238,000, Anne Arundel $222,000, Frederick at $219,000, Baltimore County $218,000, Charles County $204,000, and Prince George's County at $199,000. I ask that you please allow Prince George's County to correct this misalignment and raise the compensation for the future state's attorney. As I mentioned before, this will not affect our incumbent state's attorney. And I will add that our state's attorney office, the volume of the cases that we have, I believe is the largest volume in the entire state, more than Baltimore City, more than Montgomery County. And so for those reasons, we are respectfully requesting a favorable vote on House Bill 1222.
Thank you. This concludes the favorable testimony. Any questions for this local bill? Seeing none, this concludes. Oh, okay.
What's the lowest paid one? Do you know across the state?
I don't have a list of all of the ones across the state, but I know you're from Howard County. I think Howard County is higher than us as well.
Yeah, no, I think you did mention. I was just curious. I can look it up. Thank you.
Okay, no problem.
Okay, thank you. This concludes the hearing on HB 1222. Thank you so much.
Thank you.
All right, we are going to hear from Delegate Guyton with HB 1383.
Thank you so much, Madam Chair. It's great to see you sitting there. Delegate Michelle Guyton for the record. Committee, it's wonderful to be before you again, and I bring to you today for your consideration and hopefully a favorable report, House Bill 1381, addressing children in need of assistance permanency plan requirements. I think what we would love for you to understand is that children all have very unique needs, particularly children who are in need of assistance and are wards of the state. In my other life outside of here, I have been a part of these review hearings that determine permanency placement and the success of those. And I'm very excited to bring this bill to you because I think one of the things being left out of that process really is the unique need of each child and the ability of their placement to support, whether it's their health supports, their mental health supports, their educational needs, many other issues, particularly when it comes to kids who are going through transition, and we want them to have the tools that they need to be successful after they turn 18 and are on their own. So that's why I bring this bill to you, and I'm going to turn it over to my panel to give you more information, but I truly hope that I can get your favorite report on House Bill 1381. Thank you.
Good afternoon, Chair and members of the committee. My name is Erica Lamont, and I serve as the Advocacy Director for Children's Rights for Maryland Legal Aid. Thank you for the opportunity to testify in strong support of HB 1383, and thank you, Delegate Guyton, for bringing this bill. Every day, Maryland Legal Aid represents thousands, and we have thousands and have for years represented thousands of children across the state of Maryland in child in need of assistance cases. Right now, Maryland law requires agencies to make reasonable efforts, but the term is defined only in the broadest of categories. In practice, this means that expectations are very dramatically different from case to case, jurisdiction to jurisdiction. HB 13 brings clarity, consistency, and accountability by defining reasonable efforts in concrete, reviewable terms that reflect what children actually need to thrive. And let me explain how this works for those of you that don't do this practice. So what happens is the department is responsible for providing certain reasonable efforts to meet the child's needs. We use these, what the court has, or the statute has now, in trying to hold the department accountable when they're not meeting the child's needs. But without specificity, it's very difficult for the court to make a non-reasonable efforts finding. It's very difficult to hold the department accountable. Actually, this bill is better for everyone, including the department, because in our experience, when this body changed the part of the statutes that's below this regarding when you turn 16, that part has specificity in it. And because of that, the department changed the way that they interacted, the way that they created their court reports, and it improved some of the accountability that we were able to bring for those clients. And we would like to do those for the rest of the clients, of the rest of the foster children. We request a favorable report, and I'm available for any questions that you may have. Thank you.
Teresa.
Good afternoon, Vice Chair Davis and members of the committee. For the record, Teresa Hessler, and I'm here today on behalf of the Maryland Association of Resources for Families and Youth, also known as MARFI. We are in strong support of House Bill 1383. This bill recognizes something very important, that permanency is not just about where the child lives, it is about how the child lives. HB 1383 strengthens permanency plans by requiring attention to the full spectrum of a child's needs, their physical health, their mental health, their educational continuity, their safety, their social development, financial literacy, their housing stability after case closure, and even the simple but critical manner of basic identification documents. For youth in foster care, meeting these needs can mean the difference between building a future or scrambling to find their footing. A child cannot enroll in school without proper records. They cannot access services for health. They cannot build independence without financial awareness, and they cannot heal without access to the mental health and therapeutic needs that they may need to access. The bill ensures that planning is intentional, comprehensive, and future-focused. It is about raising the standard from placement achieved to youth prepared. And for these reasons, we respectfully ask a favorable report on House Bill 1383. Thank you.
Thank you. Ms. Phillips?
Good afternoon, Vice Chair Davis and members of the Judiciary Committee. My name is Diana Phillip. I'm the coordinator for the Coalition to Protect Maryland's Children. This bill, 1383, is actually one of our 4 priority bills this session that is child-centered. And we're looking at what the child needs, because a child that has been placed in the care, custody, control of the state deserves the best possible moving forward in transitioning into adulthood. This bill comes from the concerns from foster parents, the CASA volunteers, the synod attorneys, and others who are concerned that there are different jurisdictions and their interpretation about reasonable efforts and what that means for a young person who's aging out of care or going into a permanency planning process. So what we believe is that this bill is bringing clarity and guidance. So that way, local departments, the Senate attorneys, the judges, they have expectations, but so do the youth. They have an understanding now instead of these vague terms about what that actually means, the things that need to actually be addressed, and the timeliness in which they should be addressed. We are aware that the Department of Human Services has an information-only letter with some of the concerns, and we're quite prepared. We have a rebuttal document that we'll share with you, and we're willing to actually talk about this at this hearing, but we feel that there's no need to amend this bill. It's very simple. It's a very straightforward bill in which we actually are just making a little bit more detail about what those vague terms are for reasonable efforts. And on a personal note, both my parents were foster care kids, and my dad aged out of foster care. When he met a friend of mine in New Mexico who actually does do SINA cases, he said he didn't know that at some point in the United States, we decided to give foster care kids lawyers, and that somebody was actually looking at all the aspects of what it took for him, kids like him, to be successful. And I think about my dad, no one set up anything about his dental care, and he needed it when he was young. No one set up anything about his mental health for the trauma that he endured. And for these reasons, we really believe as a coalition for a favorable report on House Bill 1383. Thank you.
Thank you. We have one virtual witness, Macy Wilson.
We do not have anyone under that name.
You have anyone for this?
We have Laura Wilkes, and I'm from 15.
Okay. Macy Wilson is not here. Questions?
She just texted me. She said she was in the waiting room.
If she's the I'm 15.
Yes.
Okay.
Yes.
Okay, Macy Wilson, you can proceed.
Hi, good afternoon, Chair and members of the committee. My name is Macy Wilson, and I'm a former foster youth here to speak on strong support of House Bill 1383. It is such an honor to speak here today on behalf of all former and present foster youth. Growing up in foster care, one of the hardest parts wasn't the moves or even the uncertainty. It was how all of my needs were going to be met and treated with vague options. Adults around me would say they're working on it, but weeks and months could pass without anything actually happening. This bill finally makes sure that reasonable efforts are made and not us just being told things. I had a huge gap in my education when I was in care. It not only affected me then, but affects me now as a current college student. I feel like I'm playing catch up sometimes. I can't imagine how many other children feel this way. And if there are other children that feel this way, I want you to know that you are not alone. This bill will help fill so many gaps for children, and not just in education, getting them ready to make things easier for them as they transition into adulthood, giving them the tools, but also the confidence to continue to become successful adults. I've heard the opposing side, but my lived experience tells different. And adding this bill isn't going to make it longer for children to be placed, and it is not a barrier. It provides more accuracy in ensuring these teens will be safe and have their needs met. Closing the gap on education and life skills would be amazing for them. I wish I had this chance when I was in care to have a bill like this, and I can't imagine how many children this bill would help. I also would like to say that I'm only 22 years old. So I recently, left foster care a couple years ago, and I think this bill would really be impactful for children now. Thank you for your time.
Thank you. This concludes the favorable panel. Questions, colleagues? Delegate Simpson.
Aren't these fiscal notes fun this year? Says no state impact, but then you read down further, and can you address why they're going to need 50-some workers?
What's listed in the bill are things that they should already be doing. I would love to hear the explanation as to why they would need more workers to do what they're already supposed to be doing. I mean, if you look at the bill, these are things that any responsible parent would do for their child.
Right, the extracurricular activities and the plan. it just expands what's already in law. You're just
Exactly.
getting more prescriptive.
And
Is
actually,
that correct?
Absolutely. And most workers that are doing a good job already do these things. They already do these things. But there are some that don't, and different jurisdictions have different outcomes.
56 additional staff.
All right. Delegate Woods, please.
Thank you, Madam Vice Chair. Thank you so much for this bill. I've always believed that anytime a child enters foster care, the number one priority from day one has to be permanency planning. And so I thank you for the detailed information. My question is, only if you can do it in less than 1 minute, can you kind of give me kind of like a summary of DHS's concerns about it being too prescriptive and how you would respond to that?
So I guess what they're saying is that because we have listed things, that they would have to do this for every child. But what it does is just gives examples. It says including. It doesn't say it's mandatory. Everything doesn't qualify for every child. Every child doesn't want to be engaged in extracurricular activities, right? So this applies to, and it's important that you look at the first word, meet individualized needs of the child. They are already responsible for meeting the needs of the child. It's just look at that particular child and find out what that particular child needs, and look at these things. Enroll in education timely. That's, they should be doing these things already. So I don't know, making it more specific and more prescriptive doesn't add responsibility. These are things that they should already be doing for these children. And including is not mandatory.
All right. Seeing no further, Delegate McComas.
I just want to ask a question. I read the letter that was sent by the acting director, and I guess I'm kind of concerned because it's like, what is the problem? Is that the department doesn't get enough support in budget-wise and in social workers, or is it just that they don't want anybody mucking in their bathtub, so to speak, or in their power structure? I mean, what seems to be the problem? Because you're right, this is, a good parent would do this, and I would assume that if you want to be a foster parent, they pretty much, look you over very carefully, and you have to be pretty savvy and approved. So what's your thought as to why this is a problem?
Thank you so much, Delegate McComas, and thank you for your support and expressing those thoughts. I think that you hit the nail on the head. They just don't want to be responsible for doing in law these things that they really should already be doing in practice. And most of them are. And I want to say, based on my experiences, I think it's important to say that most of them, particularly social workers, are really, really working hard to make sure all these individual needs are met. But I have been in review hearings and permanency planning hearings where, for instance, the issue with extracurricular activities may seem trivial. However, there was one case that I was involved in where a very traumatic experience had happened, and the only thing that kept this young person going was being able to swim, right? So in her permanency planning, it became obvious that she would not have any opportunities for any extracurricular opportunities because she was going to be a primary caregiver for a younger sibling, right? That was very impactful to the unique needs of that child. And so while even some of these things may not sound incredibly important in here, they really are. And they should be the issues that are met for each one of these children. And not having ID when you age out, not being able to drive, these are super important things, and they really all should already be part of the process. It shouldn't be about closing cases and getting kids placed. It should be about preparing them for the future and making sure that we give them a great start. Thank you. Thank you for the question.
Okay, colleagues, that concludes the hearing on HB 1383. Thank you so much for being here.
Thank you.
I am going to call HB 1457, Washington County Delegation. That's you. Okay, Delegate Valentine, you may proceed.
Good afternoon, Chair Davis, members of the House Judiciary Committee. For the record, Delegate William Valentine, District 2A, representing Washington and Frederick counties. I'm before the committee today to present House Bill 1457, titled Washington County Juveniles Truancy Reduction Pilot Program, on behalf of the Washington County delegation. This bill authorizes the Circuit Administrative Judge of the Fourth Circuit to establish a truancy reduction pilot program in the juvenile court for Washington County and adds Washington County to a list of counties already participating in the program. These counties include Dorchester, Somerset, Wycomico, Worcester, Kent, Talbot, Harford, Prince George's, and most recently, Frederick County in 2024. This legislation was identified as a legislative priority for the Washington County Board of Education during the board's pre-legislative day presentation. The board believes regular school attendance is vital in meeting the educational needs of each student. In addition to improved school attendance, truancy reduction pilot programs can initiate counseling, including family counseling, substance abuse evaluation, treatment, mental health counseling. It is through these type of direct services the root cause of students' truancy can be identified and mediated, resulting in student success, improved daily attendance, and participation. In addition to support from the Board of Education, the delegation forwarded the proposed legislation to the Washington County Circuit Court and received a favorable response from the Chief Administrative Judge. The Maryland Judiciary fully supports truancy reduction pilot programs throughout the state. The Washington County delegation voted bipartisanly, unanimous bipartisan vote of 6-0 to support this legislation and has provided a copy of the delegation's letter of support to the committee. This bill is cross-filed in the Senate with Senate Bill 715, and I would respectfully request a favorable report.
Thank you, Madam Chair. So I'm just curious, has other counties that have implemented this pilot program shared like their successes or outcomes?
I have spoke with the good delegate in this committee about the Frederick County program, and while it is still too soon to tell, it's only 2 years in, they have handled, I would say, less than 20 cases. I mean, these are only most severe cases. This is not a high volume of cases.
Okay, thank you.
Delegate Williams.
Yes, thank you, Madam Chair. I was just going to add, I know we have this program in Prince George's County. We've had this program for a couple of years now, and we have found it very helpful. And in fact, so helpful that we are able to take in every case that our school system would like for us to take in, just because we just don't have the manpower to handle it. But it has been successful in Prince George's County.
Delegate McComas.
I just want to ask a question of the sponsor and maybe.
Delegate McComas, can you turn that mic?
I'm sorry.
There you go.
I was reading the public defender's thing, and they want to wait till the study comes out at the end of 2026. But it seems like one of our delegates from Prince George's County thinks it works very well, and so 6 months delay isn't it kind of a life for a child not learning?
I would say so. I would like to see it implemented as soon as possible.
Yeah, that's kind of, isn't that so?
Thank you. Thank you, Delegate. That concludes our bill hearing for House Bill 1457. We're going to call up Delegate Congolo for the next two bills, House Bill 1363 and House Bill 1366. And Katie Albert. Yes. Okay. Great. Whenever you're ready. All right. 1363.
Good afternoon, Madam Chair, Vice Chair, and members of the Judiciary Committee. Thank you for the opportunity to present House Bill 1363. This legislation was brought to my office by a constituent who raised concerns about repeat domestic violence offenders and the lack of accessible information that could help protect future victims. Their experience highlighted a gap in how patterns of domestic violence offenses are tracked and communicated. House Bill 1363 seeks to address the gap by creating a domestic violence offender registry for individuals who have been convicted of multiple domestically related crimes. This bill requires registration after a second conviction and establishes increasing registration periods based on the number of prior convictions. Most importantly, this registry would make certain information publicly available in a way that promotes transparency while still protecting victims. The registry would include information such as the offender's name, date of birth, and conviction information, but would not include sensitive personal information such as social security numbers or driver's license numbers. This concept is modeled after legislation recently enacted in Tennessee known as Savannah's Law, which created a registry for persistent domestic violence offenders. That law was inspired by the tragic murder of Deputy Sheriff Savannah Puckett by a partner who had multiple prior domestic violence related offenses that were not easily identifiable in public records. As we developed this bill, we reached out to Tennessee legislators who sponsor Savannah's Law and received valuable guidance from them about how their legislation was drafted and implemented. Their experience helped inform our approach here in Maryland. One of our key goals in drafting this legislation was to keep the fiscal impact as low as possible. To accomplish that, the bill leverages the existing technology and infrastructure already used for Maryland's sex offender registry, rather than creating a completely new system. Additionally, the bill allows for reasonable registration fees and establishes penalties for failure to comply with registration requirements. These provisions help offset the administrative costs associated with maintaining the registry. Domestic violence is often a pattern of behavior. When those behaviors or patterns are difficult to identify, it can leave future victims vulnerable. House Bill 1363 provides a practical tool to improve transparency, strengthen accountability for repeat offenders, and give individuals better information to help protect themselves and their families. For these reasons, I respectfully request a favorable report on House Bill 1363.
Good afternoon, Chair Bartlett and members of the committee. My name is Katie, and I'm speaking today in support of House Bill 1363. My support for this bill is deeply personal. I'm here today because of the loss of my cousin, whose death is suspected to have been the result of domestic violence. Losing her has forever changed our family, and it has made me think deeply about what information people have or don't have when entering relationships and trying to protect themselves. Right now in Maryland, it can be very difficult to identify whether someone has been convicted of a domestic violence offense. When searching court records online, those cases are often listed simply as a degree of assault without clearly identifying that the crime involved domestic violence. For survivors and for individuals trying to make informed decisions about their safety, that lack of clarity creates a serious gap. Because of that gap, many people have turned to social media groups and apps where individuals share their experiences with certain partners or people they have dated. These spaces exist because people want to protect one another, but they can also spread unverified or false information. A domestic violence registry would provide something much better, a reliable, verified source of information that Marylanders can trust. Ultimately, this bill is about safety and informed decision-making. Giving people access to clear, verified information could help protect lives and prevent future tragedies. My cousin should still be here today. If access to clear information can help even one person recognize a pattern of violence and walk away before it becomes deadly, then this bill is worth passing. Thank you for your time and consideration, and I respectfully urge a favorable report on House Bill 1363.
Thank you. Members, do we have any questions? Seeing none, that concludes this panel. We are going to move to our next panel for unfavorable. Just me? just you. So that would be Lori Ruth.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Lori Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence, and we are in opposition of this bill today. You know, I know that it's well-intentioned and it's uncomfortable in a way to have to oppose something like this, but I am not alone. The coalitions across the entire United States are opposed to these uniformly. The National Network to End Domestic Violence is opposed to the DV registries. I have added their sort of one-pager to my written testimony. And, you know, it's that over, if I could characterize it broadly, I don't think these registries are going to do what people want them to do. So we know statistically that most perpetrators of domestic violence are not convicted to begin with. So the idea that this registry is going to accurately represent some dangerous person or type of person out there is very flawed, because the delegate just said after the second conviction, on page 3 at the bottom it says, excuse me, I turned the page over wrong. On page 3 at the bottom it says convicted of at least 2 domestically related crimes. And so it's either 2 or 3, I can't quite tell, either on your second conviction or your third. Nonetheless, since very few people ever get convicted, it doesn't really demonstrate the depth or the weight of this problem. And we also don't know, I don't think we have the statistics about how reliable the state's attorneys are about designating crimes as domestically related. I know it's improved vastly since we first passed that bill, maybe, I'm going to say 8 or 10 years ago, but I could be making that up. And so it has improved, but I still think that there's an unreliability on having to rely on that. I also think that once you know the name of a perpetrator, because of the nature of domestic violence, it's pretty easy to figure out who the victim is. And so all the coalitions and the national group worry about the identification unwillingly of victims just because of the nature of what this is. This is all in my written testimony, and for those reasons we oppose this bill. Thank you.
Thank you. Members, do we have any questions? All righty, seeing none, thank you for your testimony. And that concludes the bill hearing for House Bill 1363. We're going to move to House Bill 1366. Delegate Congolo.
All right. Good afternoon again, and thank you for the opportunity to present on House Bill 1366. So this legislation was brought to my office by a constituent who experienced firsthand the flaws in Maryland's current protective order framework. The constituents share concerns about situations where a respondent is placed on probation for an offense against a victim, but the protective order protecting the victim may expire before the probation period ends. So House Bill 1366 fixes this problem. Under current law, final protective orders typically last up to 1 year, and in some cases up to 2 years. However, those timelines do not always align with the timeline of a criminal case or the probation period imposed by the court. This bill ensures that when a respondent is placed on probation for an offense committed against the petitioner, the court has the ability to extend the final protective order through the period of that probation. The goal is simple: to ensure that victims are not left without protection while the respondent remains under court supervision. After introducing the bill, my office worked closely with the Maryland Crime Victims Resource Center to strengthen the legislation. Based on their experience and feedback from advocates who work directly with victims, we developed an amendment that clarifies the process. The amendment allows the court, upon written request of the petitioner or the state on the petitioner's behalf, to extend a final protective order through the respondent's probation period when the probation is for an offense committed against the petitioner. This approach ensures that the bill works smoothly within the existing court process while maintaining appropriate judicial discretion. HB 1366 is a targeted and practical change that helps align protective orders with criminal probation timelines and strengthens protections for victims of abuse. For these reasons, I respectfully request a favorable report on House Bill 1366. Thank you. And the proposed amendment.
Thank you. Members, do we have any questions? Delegate Simmons?
Thank you, Madam Chair, and thank you, colleague. I see here the judiciary weighting is unfavorable. Has there been any conversation with them? Was y'all able to come to any resolution?
Unfortunately not. We did follow up with them. They are opposed to the bill altogether.
No, thank you.
Do you have a comment on the indefinite and disproportional orders that could be created by the bill? You know, because some people get probation for, you know, X period, and then some people get probations for a lot longer. So that's something that the judiciary brought up, and I just wanted to see if you wanted to address that.
So I don't have a direct response. Well, I'll say this, is that what the goal of this is if they are under probation or they commit an offense related to the domestic violence or something related to, what they've perpetrated or against an individual, is that protective order will be aligned with that probationary time period.
Okay. So like if there's an assault.
Right.
And then, so there's a criminal side with the assault, and then you have the protective order. And it says stay away for 1 year, but the probation is 2 years.
2 years, right.
Okay, got it. All right, members, do we have any other questions? Delegate Cardin?
Thank you, Madam Chair. Thank you for the bill. Does a judge have the ability to extend a protective order if they find the circumstances warrant it past a year?
So they can, but what we want in this bill is at the request of the respondent, the person who requested, that the judge takes that into consideration when extending the protective order.
Okay, so if you have a respondent who is put on probation for whatever reason, the probation's transferred because he lives in a different jurisdiction. He's following everything he needs to, but the protective order indicated that the judge realized they just need to be away from each other, and the best thing would be for him to move to another jurisdiction. So now they're doing exactly what they want to try and avoid having to deal with this, but it seems like by doing all that, they're now required to extend this, which is what they're trying to, and maybe both parties say, well, yeah, if we can get that to work out, we don't need this anymore.
Right, and it's not a requirement, it's just saying that they have the ability to. So there is no requirement to, well, in terms of it having to happen, we want it to be something that's available to them. Okay. I hope that makes sense.
Yeah, okay, thank you, Madam Chair.
Thank you. Members, we have other questions. Delegate Conaway.
Thank you, Chair. Thank you, Delegate, for bringing the bill. So if we look at this a different kind of way, this kind of helps both parties because no one can be confused about when they can make contact and when they should not make contact. So by you being on probation the same amount of time that you should stay away, you have one date, no confusion. Is that correct?
It's a win-win for both, especially the victim.
Well, I was trying to help you, but thank you.
All right, members, any more questions? All right, seeing none, that concludes our bill hearing for House Bill 1366. Yes. Oh, yes, I'm sorry, we certainly do. We have Laura Wilt online, favorable. Hello, good to see you.
Hi, good afternoon, Chair and members of the committee. Delegate Congolo, thank you so much for sponsoring this legislation. I'm sorry I could not be there in person today. I'm Laura Wilt, Senior Attorney in Baltimore City for Maryland Crime Victims Resource Center. Domestic violence victims rely on protective orders differently as essential tools to help keep them safe. Protective orders can help provide a sense of stability and protection while victims attempt to rebuild their lives. This bill recognizes what I think most non-lawyers don't understand, that protective orders are different. They provide help that probation conditions cannot. Protective orders are actionable in a moment of crisis, where probation conditions are only enforceable after the fact in the courtroom. So if a man, for example, is placed on probation, he shows up at the victim's house, banging on the door, she can call the police, but they can only tell the man to leave and then report it later to the probation agent. The minute the perpetrator or the officer leaves, the victim then is rightfully in fear again that he's going to return. If a protective order had been in place, then the officer, if they see them violating the protective order, they can arrest the violator, keeping the victim safe. After a person has been found guilty of a domestically related crime, a court has ruled that they should be supervised in this case and stay away from the victim. So extending the protective order for the same period of time is a common sense approach and strengthens protections of victims. Victims live with long-lasting emotional consequences of abuse. They're rightfully alarmed when a police officer tells them they can do nothing to enforce a probation's stay-away condition. We need the protective orders because they're much more effective. We respectfully ask that you support the physical and mental well-being of victims with a favorable report on House Bill 1366.
Thank you. Members, do we have any questions? Seeing none. Thank you, Ms. Wilt. Have a good afternoon, evening.
All right, thank you.
Or whatever it is. Thank you. There's no time clock in here, you know. We just go. We just go until we get the work done. Delegate Bandari, we're going to call up House Bill 1541. Okay. So, okay, hold on 1 second, Delegate. So, do we have one witness listed?
She could not make it.
Okay, no worries. I'm sure you will be more than adequate. Thank you.
Yeah, thank you. Good afternoon, Madam Chair, Vice Chair, and member of wonderful Judiciary Committee. By all accounts, Sagar Gemire was a bright young man with a promising future, a recent graduate and aspiring data scientist. He moved to Baltimore County with hopes and continuing his education and building his life here in our state. But those dreams were tragically cut short. While settling into his new home in Woodland, Sagar and several members of his community were killed in a senseless act of violence. He was only 24 years old. I remember how deeply this tragedy shook the community. When I learned of the incident, I went to the neighborhood to support grieving families and residents who were searching for answers. What made this loss even more painful was the knowledge that warning signs had been observed beforehand. Neighbors had expressed concern about troubling behavior by the individual responsible. Many felt unsafe, and there was no clear pathway for those concerned to translate into preventive actions. That raises an important question for all of us as policymakers. When warning sign exists, are we doing everything possible to intervene before tragedy strikes? That is the question behind House Bill 1541. Maryland already has an important preventive tool known as Extreme Risk Protective Order, often called the Red Flag Law. This law allows a judge to temporarily restrict access to firearms when someone poses a credible risk of harm to themselves or others. Petition can be filed by law enforcement, family members, spouses, or a household member, and certain health professional. If granted, the order temporarily removes firearms and prevents new purchases while the court reviews the situation. The purpose of this law is simple: to intervene early when credible warning signs appear and prevent violence before it occurs. But passing a law is only first step. The real question is whether the system is working as effectively as it should. House Bill 1541 does not change that red flag law. Instead, it takes a careful and responsible step by establishing a temporary work group to study how extreme risk protective orders are functioning across our state. The work group brings together key voices from across the system, including the Secretary of Health, the Attorney General, the public defender, law enforcement leadership, and mental health expert. Together, they will evaluate how ERPOs are used, identify barriers in the system, and recommend improvements to the General Assembly. I appreciate the Maryland Department of Health engagement on these issues. However, I respectfully believe the concern raised in their opposition letter misunderstand the purpose of this bill. Existing initiatives cited by the department focus primarily on suicide prevention and public health awareness. While those efforts are valuable, none provide a comprehensive cross-agency of how ERPO's laws are actually functioning across the state. And this is not the first year I'm bringing this bill. This is a real issue, and I would respectfully ask committee to give a favorable report on this bill. Thank you.
Thank you. Members, do we have any questions? Delegate Simmons.
Thank you, Madam Chair. How you doing, my colleague?
Wonderful.
Outstanding. Can you talk a little bit about the health report from the Maryland Health Department, and have you been able to work out anything with them and they're unfavorable?
Yes, thank you. I would like to thank our health department for sending the letter. And absolutely, I emailed them, they emailed me back. We'll be definitely working together. And, you know, they claim that, the department claimed that this is a duplicative existing work. This bill integrates expertise from public health, public safety, and the justice system into one coordinated review process. When the incident took place in Baltimore County, I reached out to Attorney General. I got the big bulk of 90 pages, the report, and how the bad actor had shown different type of erratic behavior, but we were not able to do anything. The law is there. This is the time whether the law is working or not. That's the bill says, and there is a sunset. We're gonna bring all together and you know, study it, whether that law is working or not.
Sure, so is this something that rises to a gap in the legislation that we need to readdress it, or is it something that the department itself can handle based on your concerns or your constituent concerns?
Thank you. Department cannot. Is their concern more like suicidal prevention? And, you know, as you said, there is a law, red flag law. We need to look whether that law is working or not. Extreme risk protective order exists to prevent tragedies, but we must ensure that the system is designed to save lives is working as effectively as it can. And we cannot bring those innocent people back, but we can learn from what happened and strengthen the tool meant to protect our communities.
So, Delegate, have you written to the Department of Health and asked them to study in their existing group, to study or to broaden their study in their ERPO advisory board that they have? Actually, I guess that would be the Marylanders to Prevent Gun Violence has the advisory board. But have you written to them and asked them to expand their capacity to include some of the areas that you are mentioning?
Yes, thank you, Madam Chair. As I mentioned, existing initiatives cited by the department focus primarily on suicide prevention and public health awareness. As you said that, I have not talked to them about the particular issues, but those efforts are valuable. But none provide a comprehensive cross-agency evaluation of how ERPO's laws are actually functioning across the state. So I think this bill will look deeper into it.
Thank you. Delegate Cardin.
Thank you, Madam Chair, and thank you very much, Delegate Bhandari, for bringing the bill. And I applaud you. You're always very well prepared. And it's, no matter what you're doing, it's very impressive. My question is, it looks like this goes into effect June 1st, about 2 weeks before the primary election. And the report's going to be due about 100 days after the inauguration of the new governor to the new governor. Could be the same governor, but it could be a new governor. Do you think that maybe this year is not the right year to do this, if we're going to do it? I understand, and condolences to the person who lost a family member and Baltimore County, of course, we always have issues in Baltimore County, but maybe we should wait until next year?
You know, thank you, Delegate, for a wonderful the proposition question. When you are doing the good thing, you should not wait. Like for this, I know the parents of Sagar Gimire is in Nepal, and his sister is here. I mean, Dad all the time reach out to me and say, "Did you do something?" I mean, he doesn't like his wish is, yes, there is a law in effect, but why my son was very young, got killed so young? He just want answer, nothing else. And so I believe at least, not only Sagar Gimire, there are a lot of people, and I understand that's a mental health thing. I do understand that as well. But we should be very much open, delegates, and I think there is issues. There is issues. I talked to our former county executive, now Congressman John Yo, our Attorney General. They supported the bill when I introduced first time, and I've been bringing this bill every year, at least, you know, making sure that the problem exists there, rather than finger pointing at each other, at the agency, to cross agencies. I think this is the time that we need to be very, very careful and look at it.
Thank you.
Thank you. Delegate Conaway.
Thank you, Chair. Thank you, Delegate, for bringing the bill. So what were some of the extreme risk behaviors that the, I guess you would call defendant was demonstrating?
Thank you for that question. The perpetrator had long been on the radar for law enforcement.
Had been on the what?
I mean, radar, like the law enforcement reached out to him multiple times. About his behavior, erratic behavior, right? And he had a hallucination. He would say that somebody is really watching me. One time he protested in front of White House as well. And neighbors reported that he often confronted them, accusing them of spying on him, you know? And on one resident who had registered concern to the police, you can read on the Baltimore Sun, you can find on the papers during that time, they covered it extensively like a ticking bomb. And, you know, in the tragically Sagar caught in the blast. It was early morning, you know, and his family was left to wonder why, if the clues were there was no action taken which might have prevented this incident. So yes, like a lot of community members, when I went there, he was not behaving normal. I was there after the incident took place, and you can, if you just Google it, Sagar Gimire, you can find a lot of report what happened. You know, it's very tragic, but hopefully we could have intervened. Therefore, the whole intention is we have a law in place, but it's our responsibility that whether that is working or not. I mean, and it doesn't cost a lot of money. And if you look at the fiscal notes, the analyst said that even though department says it costs money, but they could complete this study within their existing resource. That's what the fiscal note says.
Thank you very much.
Delegate McComas.
Thank you for bringing this. Obviously, was his family, the perpetrator's family, aware that he had serious mental issues?
I have no knowledge.
Okay.
Madam Delegate.
Perhaps, well, but somebody knew he was kind of.
The neighbors. Mm-hmm.
The neighbors. And were they fearful of him? If they would have, you know, kind of got somebody involved, or like, because some of the counties have a, I don't know what you call it, but in other words, that they will come to the house if somebody's having emotional issues, crisis intervention, right? And they have a team, and they, I think it's police and the therapist and stuff, and they make sure that the person gets the right kind of medication, or, you know, right kind of services, and that they can get over the incident. So was anything like that in Baltimore County to service this person, if somebody knew about it?
Yeah, thank you. I could get back to you. And yes, definitely, we do have that system, but I have to do a little bit deeper research and can get back to you and your office.
Okay. Well, it just seems to me that people just don't know that there's different assets there that can maybe stop this kind of a tragedy. I mean, it's not, it's not going to bring him back, but at least something. But it just seems like we all need more education on mental health.
To your point, yes, this work group definitely would recommend some sort of ways to couple this intervention with mental health support for individuals who need it. That's the whole idea.
Okay. Thank you.
Absolutely.
Thank you. Members, do we have any other questions? Seeing none. That concludes our testimony for this bill hearing.
Thank you.
Thank you so much for being here.
Thank you.
That concludes our bill hearing for House Bill 1541. We're going to move on to Delegate Ross, House Bill 1568. And my understanding is that the bill will be presented by Samuel Inuwami.
That's correct.
All right.
Yes, hi, Madam Chair, how are you?
Well, we don't allow that. Yes, we do.
I was going to say, no. He's ready to do it. It is a pleasure to be here with you in your committee. I have.
This is your first time in our committee?
It is.
Oh, well, there you go. Welcome.
Favorable. I moved to favorable. Madam Chair, thank you. Madam Vice Chair, it's a pleasure to see you as well, and distinguished members of this committee, truly. So I have a long list of bills today, and so my intern is prepped to do this hearing, and I'd like to let him continue to do that, and I will, if I'm called out, I'll be heading to another hearing, but I'll try to assist with technical questions.
You may begin whenever you're ready. Good to see you.
Okay. Good afternoon, Madam Chair, Madam Vice Chair, and members of committee. My name is Samuel Inuyomi. I'm a legislative intern. I'm presenting this bill on behalf of Delegate Kim Ross, Baltimore County, District 8. I'm here today requesting a favorable report for House Bill 1568. This bill is simple. It required each county and municipality to adopt laws or ordinances prohibiting a dog from being off-leash. Most of our jurisdiction already has these laws locally, but what this bill will do is make sure that they continue to those ordinances and establish penalty that includes both civil and criminal penalties for violations. House Bill 1568 is not dictating what the county's ordinance needs to be. They will continue to have authorities over their leash laws. This is just making sure they have one of these bills. The bill is not costing anything, but not having it can cause a lot, like property damage, injuries, claims, and the likes. It is about public safety for people and for pets. Again, I respectfully ask for a favorable report for House Bill 1568. Thank you.
Thank you very much. And we have, I don't know your rank, but I'll say Park Police Robinson.
Yes, thank you. Good afternoon, Chair, Vice Chair, and members of the committee. My name is Lakeisha Robinson, and I am the Chief of Montgomery Parks Park Police. I am here today on behalf of the Maryland National Capital Parking Planning Commission to express our support for House Bill 1568. House Bill 1568 would require counties and municipalities to adopt local laws prohibiting dogs from being at large and to include enforcement provisions. Importantly, the bill preserves local authority over enforcement and allows jurisdictions to adopt more stringent measures based on local conditions and needs. In our parks, leash laws and dogs at large rules are core public safety tools. They help reduce dog bites and fights, prevent wildlife harassment, and support safe shared use of trails and park amenities by families, runners, cyclists, and other visitors. Commission Park Police already enforce these requirements on commission property through warnings and civil citations, and we track violations over time. Based on our current practices, we believe this legislation can be implemented using existing resources without creating operational challenges. For these reasons, the Commission respectfully urges the committee to issue a favorable report on House Bill 1568. Thank you.
Thank you. I have a question. So I wanted to know, why did MACO and MML oppose the bill? And I see they're saying that it would actually create a big burden on the counties and the municipalities because they would have to reopen its legislative process, conduct public hearings, revise the code, and retain enforcement personnel, despite already having functional and enforceable dogs at large provisions. Can someone address that, please?
I'd love to, and then I would defer to Mako to flesh that out a bit more for me as well. This, as far as operational challenge, I've seen no specifics as to what would that those challenges would comprise. What I do know is that virtually all of the jurisdictions in Maryland already have ordinances related to this. They already have said that we care about this. This is just making sure that they continue to commit to that. My office has heard from numerous more rural jurisdictions that these laws get relaxed over time, that socially, culturally, we become more immune to it. The idea of dogs running off leash sounds more romantic than it actually is in practice. And there's a fear that over time, as different folks get elected and come into office, that they may have a different view. So this just makes sure that the counties do not move away from what they already have committed to do, one. And then two, I would say, so there's already an appetite, no pun intended, on the local level for this kind of legislation. We know that. It's, so I would also say that you mentioned the updating the code and legislative process. In some counties, I represent Baltimore County, Eastern Baltimore County, and as a charter county, our code updates are not extensive. Those updates can be handled through a very basic legislative process with the council members voting on it with the majority vote. The charter, updating the charter, as some of the Baltimore County representatives here well know, requires a little bit more. They've got to get things on a referendum, they've got to take it to the ballot, and they got to get the public to say that we want this. The public input piece is always up to the council to determine. They may decide to do that, but I think that is an investment of time that is absolutely, the return on that is absolutely there. This is a public safety bill, and this is about keeping people safe. My intern said this very well, and I applaud him for that and the job that he's done here today, that this doesn't cost anything to implement, but it costs a lot not to do it. This is making people less safe. I've experienced it. I was there when a 7 or 8-year-old in my community was attacked by 3 Cane Corsos who killed her dog and injured her. I know of other colleagues who have experienced things. So when we talk about having to make some changes to the code or having to adjust your ordinance, well, the return on it, is the return there? Does that justify the time that you put into making those updates? Absolutely. It's keeping people safer. So it's opposition that I hear and I understand, but I would be embarrassed to make it when you compare it against not doing it. So Mako, please provide some specifics as to what those operational challenges are. I'd like to see something itemized if you have that or can get that from some of your jurisdictions that may have said this would be a challenge for them. But I would say to the committee, barring anything like that, I would question that, to what extent this is a burden.
Okay, thank you. Delegate Woods.
Madam Chair, thank you, Delegate Ross. You and I have talked. And I am one of those colleagues that she's referring to who had the unfortunate incident last year in July of having my neighbor, I've been friends with for many, many years, attacked by a dog. She's a senior citizen. And that same dog I observed attacking a child just a couple of months later. And I had to be the one that was on the news, if those of you didn't know this. I was the one who went out and had to go out after that dog because I was told that dog, no, I had a shovel. It was a shovel, I had a shovel. And as neighbors watched, because everybody was afraid, but being told that if I had not intervened and made that own sacrifice myself, that that dog could have killed that little girl. And so I am in total agreement with this. And I say to my colleagues, is it not so that to protect people from these types of assaults is extremely important? That is my question. Thank you, Madam Chair.
Thank you, Delegate. Well, the lights have multiplied. Okay, we're going to go to Delegate Stinnett because his word's up first.
Thank you, Madam Chair. Thank you, Delegate, for bringing this. I just want to get some clarity as far as when we say dogs at large, to what extent being at large, and I'm thinking that it's outside of their immediate area, saying the property owner's home, or is that part of being at large if they're unleashed?
Yeah, so what we've tried to do with this bill, because there is a dog bite law that is on the books that is good, and we're not seeking to make any changes to that law. That law defines at large, and it gets into great detail about what you're asking right now. This bill is mostly just saying that it's a dog leash bill, so it's not a dog bite bill. This is just saying they have to be leashed, or you have to have an ordinance that says that they must be leashed per that prior legislation. So it's defined in there in a very broad way that is very, very good. That's essentially saying, and it allows for basically, if your dog is off leash and hurts someone, that there's a whole range of recourse that can happen for the victim, that person can, has a lot of latitude to seek legal recourse. And the onus is placed, you know, there's some onus that can be placed on the owner and those sorts of things. And so respectfully, we've tried to, with this bill, not get into the granular details of that, just because there's a statute already around that. And just for us, for the purposes of this bill, we're just saying that you need to have, every county needs to have an ordinance that addresses the matter in a serious way. And the most important part of this bill is that it must include, your ordinance must include civil and criminal penalty. How they structure that is completely up to the county to decide. And I've said this to Mako, I met with them, that this is, we're not mandating that you do it in any particular specific way. We're just saying that you need to have something. So, and it needs to have the criminal component in there. You can say, as for your county, we're not going to apply criminal violations until, you know, you do it for the 250th time that your dog is off leash. Then you're going to face something more serious. What this law will say is that it needs to be in there, that criminal component. Where you apply that and at what point that kicks in, it's completely up to the jurisdictions to decide. This is not an overly aggressive or overly oppressive bill, really. You know, it's really just saying that you can determine it, but it needs to be in there so that we don't have jurisdiction saying, it's not that serious. When your dog is off leash, you get a pat on the hand and we're going to fine you $10. This keeps that from happening.
Got you. Real quick, Madam Chair. So the reason why I'm asking is that, you know, I have a constituent that that next door to her are some dogs that are actually doing some damage to her fence, and even to the extent of trying to dig underground to get on the other side. So does this bill addresses something in that nature?
Right. So I think the dog bite bill goes into some detail that you may want to see. And if it's all the same to you, we will get that bill to you by tomorrow.
Sure, thank you.
That legislation to you by tomorrow. And you can see sort of what it covers, the range and how it's defining at large and all those things. And then for this bill, it's really just about, must have an ordinance on the books that says, that addresses the issue and covers, has civil and criminal components. But I will get that bill, we will get that language to you, that legislation.
Great, thank you, Delegate. Thank you, Madam Chair.
Can you note that?
Thank you. Delegate Cardin.
Thank you, Madam Chair. Thank you, Delegate, for bringing the bill. So you already answered the question about MAKO and MML, but there's, so the dog bite legislation that you were referring to defines a dangerous dog, right? Okay, so, and there's strict liability. That was, I remember, that was think it was Delegate Zirkin, it may have been Senator Zirkin.
Senator Zirkin,
I can't remember, I think it might have been when he was a delegate.
probably.
But he worked, he actually did dog bite work and was passing dog bite legislation. But be that as it may, it was a strict liability bill that basically said that if your dog is determined to be a dangerous dog, and you kind of get a one bite at the apple, no pun intended, that you are going to, there could be serious civil consequences to that. Okay. But this bill, the way I read it, requires first of all, do the counties now have ordinances or laws regarding, do all counties have it, or are there some counties that don't have it?
Our research is showing that the vast majority do.
So wait, okay, so most counties or all counties already have this on the books?
Yes.
Okay.
They have ordinances.
So, but we're going to require them to do it again?
No. So we're going to require them to, we want to be sure two things occur with this bill. One is that those ordinances don't go away. So as we know, as legislators, we cycle in and out. Like
I understand.
Yeah.
So you want to make sure that they don't go away.
And then two, we want to make sure there's a criminal component. Some of the ordinances currently do not include that. So you could be in violation for 500 times and be facing the exact same penalty without any escalation every single time.
Right.
And this bill is going to require that.
If you do have a penalty, there's generally some sort of fine or fee that you have to pay, right?
Correct.
So it could be like 500. You could pay, if you did it 500 times at $500 a time, you could be in for a lot of money. Would it be worth it to continue to have your dog there? Okay, but let me just get back to, so this talks about running at large versus dangerous dogs. And the way I read the bill, if I have my dog out on my front lawn, but there's no fence, and I have a neighbor who doesn't like me, they can have me cited, and I could then have a criminal record. And this dog has never done anything to anybody, has not ever barked at another human being or another dog, and I will now have a criminal record because of this legislation. That's the way I read it.
Sure. So Delegate, let me say this to you. First, full disclosure, you'll see Senator Zirkin is down here as one of my witnesses and favorable for the bill.
I'm sure.
We've had a number
He
of
and I don't
conversations.
always agree on dog legislation.
Oh, I can tell. I picked up on that.
And we're good friends, by the way. We're
You
very
are good friends and you don't agree on the bill. That's okay. You just don't talk about this over drinks, I guess. He has been a great consult on this bill. And unfortunately, he let me know earlier today he was pulled into court. I'm sure this committee can appreciate that. A judge required him to be there, so he couldn't be here today. He would have been fielding these questions with you. So let me give it a shot, though, in his absence. What I will say to you is this. So this bill is not saying that you would have a criminal record after the first time. This bill doesn't say that. What this bill says is that your jurisdiction, Baltimore County, they must have an ordinance that includes criminal penalty. How they structure that is completely up to them.
And if the county decides, you know what, our decision on criminal penalties is that we don't want to issue criminal penalties, so we're not going to have a criminal statute, can they do that or they can't? They're not permitted to. So the county is required to have some sort of criminal penalties.
That's correct.
Okay.
Yeah. And that would be where you get into like your public input meeting, and then you would show up and you would say, well, you better not do it until X number of times. We don't want to see our first time offenders getting hit with these misdemeanors. That's when that would come into play.
Okay. All right.
Okay. Delegate McComas?
Just briefly, I'm from Harford County, and of course we have 3 towns, but also we have a lot of agricultural properties up north, and it seems like every time I get a notice from the health department, they're concerned about rabies, a raccoon. So I sort of think that it would be good in the sense that people would keep their dogs kind of close by so that the dog wouldn't approach a rabid raccoon, because you don't know until the raccoon dies that it had rabies, really, unless it's really obvious. So I think in a way, it's a good bill for that because it helps the person with the dog. Just, you don't want to lose a dog that way.
Thank you, Delegate.
Isn't that so?
Thank you.
That is so. Delegate Taylor.
Thank you, Madam Chair, and thank you, my namesake, for bringing this bill. My question actually is to your intern. You have a wonderful delegate, don't you?
Thank you.
Should be the easiest question you've gotten all day.
And he needs to answer. She said, do you have a wonderful delegate? Okay.
She's the best.
Yes, she is. Thank you.
Thank you so much.
Thank you. And so I have a question with respect to the Chief of Park Police. Can you tell me, can you just really quickly tell us how this bill would help you and your employees manage better, or would it?
It would, and that's why we're supporting it. I got a little stats. In 2026, and it's still the beginning of the year, but so far we've encountered 8 dog off-leash complaints. We've written 2 county citations, 1 warning, and we actually had an animal bite. And one of those animal bites was actually just last month where a dog actually bit the owner and the actual dog. And so for us, and what we do is when we write citations, we keep track. And what we've noticed is we do have repeat offenders. And the park, that's open space. We have children there, and people tend to, and that's what happened in this particular instance. Someone just let their dog go thinking they were gonna run back to the car, and they didn't. They went for another dog, and then they attacked the person as well. So enforcing or giving us these additional tools would definitely help in letting people know that this is a serious offense and that people are getting hurt behind them not necessarily putting the safety of others first.
Thank you. All right, members. Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. So, Delegate, just to refresh me a little bit, the good delegate gave me an example where the dog was in the front yard and the neighbors pestering him or something, calling to say the dog is a problem. What's the problem? Let's educate the people. What's the problem with that scenario?
And I do apologize, Delegate. I'm just going to summarize to make sure I got you right. So I believe the good delegate here mentioned if the dog is off leash and it is in their front yard. Yes. And it attacks someone.
No, what did you say? It was just the neighbors just calling like, hey man, this guy over there, he's got his dog out front.
Okay, yes.
What's the problem with that?
Well, so according to this bill, that jurisdiction would determine what the problem with that is. So if your jurisdiction were to say that having your dog off leash, attacking someone, or just off leash and not attacking someone is putting you in violation, then in that particular jurisdiction, then yes, you'd face whatever penalties they had in place.
Okay, I thought you were going to cite it and say if your dog is off the leash and you don't have a fence, that could be considered as the dog is at large.
You're referring to the case, the dog bite case. Yeah, as you should. That's what we're not disturbing here today.
Yes, I got
that
you.
Law is the law, and we like that law.
A lot of people don't know that law.
Yeah,
That's
a
what
lot
I'm
of people
getting
don't. Yeah.
Yes, thank you very much.
Thank you. Okay, members, I think we beat that dog to death. Oh, that wasn't good. I'm sorry. That probably wasn't nice. I love dogs. I am a dog person. I'm sorry. I take that back. I had a dog. I want another dog. My dog passed away, but I want another dog. I'm not going to tell you what the vice chair just said. So I know on the record, I love animals. I love dogs. I've had dog bills. Buddy's Law, yes. Okay. Thank you very much, Delegate, and thank you, Mr. Pronounce your name for me so I can do it correctly.
Okay, Samuel Inuyomi.
Inuyomi.
Yes.
Okay.
Thank you.
Very nice to meet you. Thank you very much, and thank you, Chief.
Thank you very much, everyone.
Okay. Now we're going to hear from Mako. Charlotte Fleckenstein, please. Unfavorable. And this will be our last testimony for the day.
All right, I'll try to keep it as brief as possible.
Thank you. That was a hint.
Of course. Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. I'm Charlotte Fleckenstein with MACO, testifying today in respectful opposition to House Bill 1568. I'd also like to go on the record as an avid dog person. Counties certainly agree here that responsible pet ownership is a critical component of public health and safety. Certainly not suggesting that this is something we would walk away from in the future, which is why every jurisdiction already has defined dogs at large and established well-developed and thorough corresponding codes, impoundment procedures, and penalties. This is a highly localized process that is tailored to reflect the needs of each community. So our concern here is that as stands, the bill recognizes a definition of dogs at large that conflicts with most county ordinances, requiring them to conform to a new statewide one-size-fits-all expansive judicial interpretation of the term. As Chair Bartlett mentioned, this would require them to reopen their legislative processes. This can be administratively burdensome, requiring public hearings, revising code language, and retraining enforcement personnel as well. We have been in productive conversations with the sponsor about these concerns. We are very happy to follow up and continue working with the delegate and the committee on a reasonable path forward here. But as stands, MACO does respectfully urge an unfavorable report on House Bill 1568. Thanks.
Great, thank you. Delegate Phillips.
Thank you, Madam Chair. So as it stands today with MACO, and I'm assuming your colleagues at MML as well, there's no standard as to what a dog at large, how do you define a dog at large?
So I can't speak for all of the municipalities, but I will say that every county, including Baltimore City, does have a defined code. They define dogs at large, and they have corresponding codes for impoundment procedures as well as civil penalties. Most of them do have criminal penalties as well. Again, very happy to put together something itemized and follow up with the committee and the sponsor as to how that looks.
And if I have a dog, and I'm thinking about my area, if I have a dog on my front yard, in most jurisdictions, that would not be considered at large?
Correct. So most jurisdictions do define a dog at large as being unrestrained or not under the control of a responsible individual off of the owner's property. So again, therein kind of lies our concerns, is that the definition that would be adopted by the bill is from the Blitzer v. Bresky case. It's just quite an expansive judicial definition. It does define a dog at large regardless of its location vis-a-vis the owner's property. Again, would conflict with most county ordinances.
Okay, I just wanted to be clear. Thank you.
Yes, thank you.
Can I just ask one quick question?
Sure, one quick question.
Thank you very much. I was going to ask only ask one. If, in fact, a county decided to remove criminal penalties, and they could do that if they wanted. If they have criminal penalties now, but they wanted to remove them, think that it's just appropriate to be civil. If this bill passed, they wouldn't be able to do that, would they?
No, I do not believe so.
Okay, thank you.
I thought you were going to say, would you support the bill if the criminal penalties were removed? Well, you can't speak for your members.
Yeah, unfortunately, I couldn't speak to that at this moment, but if it became a future conversation, we'd certainly be open to continuing discussing with the sponsor.
Great, okay. Members, any other questions? Seeing none, that concludes our panel, and that concludes our bill hearing for House Bill 1568, and it concludes all our bill hearings for the day. Now, we are going to take a 15-minute break. No. And actually, I'll give you until 3:20, so you get a 17-minute break. So 3:20, we'll be back here. We'll have voting. All right. Thank you. We are adjourned.